in order to understand this defense, let's go back and garner up kind of a historical perspective. All right. Think about if you're a defense lawyer or if you're an insurer and you have these kinds of defendants, and I'm not talking about Union Carbide because I think they're in a whole other category, but you have a number of companies, thousands of companies that may have distributed raw fibers, and they kind of get into this same genre of if that's all they did, if all they did was sell it to someone else who used it as an end user, should they be culpable? So let's think about mesothelioma. We know in 2008 that we're starting to get to a period where most of those initial exposures would have had to have taken place at about the time that OSHA was promulgated, or at least in that area. So whether it was the former threshold limit values of the 5 million particles per cubic foot or the 1972 OSHA standards, we know that about the time that the men and to a lesser degree women that are making claims for mesothelioma were getting exposed was during this period of time when either by states adopting the ACGIH or the mandatory federal requirements under OSHA that we know that the government required the employer to take certain steps to make sure that its workers were not being exposed. And whether you agree with me or not, and I know the plaintiff's lawyers in the room won't, but does one fiber kill? I don't know that it does, and the argument is it's never been proved that it doesn't. But we have to look, at least from a defense perspective, at what we have been given. And what we have been given, are regulations, government standards that, rightly or wrongly, allow a worker to be exposed. We all know that 40 hours a week, 52 weeks a year, day to day, at a certain level. We know that level has dropped. We don't know if 0.1 is the right number. Hopefully it is, but we don't know that yet. But we have to go with what we've got, and that is that there was a standard set up, and it was set up to protect the worker, and it was the employer's responsibility to do that. So, yes, asbestos is hazardous, lead is hazardous, benzene is hazardous. There's a whole myriad of products that are hazardous, but let's put this in perspective from what the bulk supplier's role is. I guess you can just indict all of the suppliers for the mere fact that they sold it, and I'm not here to make that argument. But we have to bring to our defense what the government and what the courts have allowed us to. Now, it's universally accepted, I believe, even by the most liberal on the plaintiff's side in terms of physicians, that chrysotile exposure, it takes a lot more chrysotile than amphibole, amosite, or chrysotolite exposure to cause mesothelioma. I don't think anybody in this room would disagree with me, regardless of your background. And we know that asbestos exists in our background in the United States, and we know, at least we believe, that persons with background-type exposures are not at an increased risk of mesothelioma. So at least from a defense perspective, it still seems to be that there is some level at which the exposures become substantially causing the development of mesothelioma. Now, for some people, they just get cancer, and we don't know why. But we do know, and whether it was 60%, as I heard yesterday, or 100%, as I heard today, in terms of how many cases get into litigation, we do know, and I think the number's probably a lot closer to the 100% than the 60%. We do know that these cases are getting litigated, so we are in a position to be able to look at the actual exposures. Now, it's my belief that the plaintiff's bar has done a much better job than the defense bar in the overall at capturing these issues at trial. All asbestos at any dose is bad, and everyone knew it was bad. And again, Mark's argument was compelling, and the documents are compelling, and it makes sense. And what we as defense lawyers don't recognize is there wasn't a lot of discussion, and I understand the purpose of the presentation, but this is the way the trials go too. You impugn the knowledge of the company. You take down the company, you get the exposure in, and we as defense lawyers have an obligation to make people understand what those exposures really are and where they were caused. Now, what is the bulk supplier defense? To whom does it apply? It applies to manufacturers of raw asbestos, which is somewhat of a misnomer. You don't manufacture it, you mine it and mill it. And it's the companies, as Mark has pointed out, like Union Carbide and Than, and I think there's a number of others. I was talking to Jeff Ono about this this week. I think people don't even realize this. There are a number of other raw asbestos suppliers out there, and I'll leave the plaintiffs to kind of dredge up which of those companies still exist, but they're out there. And what is the defense? One who sells to an intermediary in bulk discharges its duty to warn if there are adequate constructions and if that company ascertains, and I think this is where Mark is focused, that the intermediary is adequately trained or informed and capable of getting this information on to others. And I think that's his point, is that it appears, at least in the instance of Union Carbide, that there was some aggressive tactics there. Maybe this wouldn't apply to them. But for those of us that have other types of defendants that might be retail suppliers or wholesale suppliers in all of the small cities and large cities in America, I think you need to look at this as a possible way in a particular state to invoke this bulk supplier defense doctrine. What isn't the defense? It's not a blanket protection to manufacturers simply because they produce something in bulk. But it does provide defenses to manufacturers or sellers of bulk product where they really don't have an opportunity to control where that product goes, where that bulk material goes, nor do they really know the purpose for which it is being used. Now, if somebody was selling amosite fiber to a thermal insulation manufacturer, they might have a different obligation, than someone who's, let's say, sold latex-impregnated gasket-like material to a gasket manufacturer with pure chrysotile. Maybe different obligations. Now, what are the duties of the supplier? It's to ensure that the vendee or the intermediary is knowledgeable and equipped to provide adequate warnings to end users. Well, why did I discuss OSHA, and why did I discuss that the men and women now that come to us with mesothelioma claims are likely to have been exposed post-OSHA or in that era and forward? Well, the reason I raise that is we keep fighting this state-of-the-art issue. Oh, we didn't know it was dangerous. We didn't know it doesn't, all those articles, they didn't really tell you that it was dangerous, and, we understood there were threshold limit values. We didn't know. Baloney. Everybody knew at this time. So let's not run from this. But let's put the obligation back on the employer and those that are responsible to protect the worker.